Ladies and gentlemen, we resume after the coffee break and after the family photo we took. I think we will all be given a chance to have a copy of this family picture to show to our friends, colleagues in the office, real family members and others. Well, I'm very glad to introduce the speaker you know already from yesterday. Roman Zykov was chairing one of the session of yesterday. Today he will present his views about the challenges and opportunities in Russia. Roman is the Secretary General of the Russian Arbitration Association, which is a newly established organization, and I'm very glad to have him on this panel. Russia is very important for the arbitration community. Russia is a very large market. Russia has a lot of arbitration institutions. I don't know how many of them are real, serious and trustful, and how many of them are not. I hope we all will learn about from Roman's speech. The floor is yours.
Thank you, Piotr. Good afternoon, very much, everyone. So Russia, as it was, thank you for the good introduction. Indeed, the arbitration market in Russia is developing. I don't know, maybe 200-300 arbitration institutions for domestic cases. They're not regulated. Basically, the quality might be very low sometimes. It varies from an institute to institute. Officially speaking, we have two well-recognized institutions, which is, and both of them are under the premises of the Russian Chamber of Commerce in Moscow. One is the International Arbitration Court, and the other one is the Maritime Commission. I would like to brief you a little bit on what's going on in Russia, what the current state of affairs, where we are, what the courts, how the courts treat arbitration, and maybe a little bit progress towards the future and how we see it. And by saying we, I mean the legal community, those 70 members, 70 law firms who are the founding members of the association. Okay, so let's break it into four parts. Legal environment, present state of affairs, developments of arbitration in Russia, and we'll speak a little bit about the arbitration association itself. The legal environment is very much conventional. You may find it very normal, very common for many countries throughout Europe or the world. We are the member of the New York Convention, the European Convention of 1961 on the international commercial arbitration. I know that some of the European states are not the members of that convention, like Sweden, for instance, is not a member. But I think the purpose of that convention was to impose a regime for dispute settlement between the West and the East. So it's a European or Geneva Convention 1961. Moscow Convention, it's a rather old instrument, and it's plausible that it applies these days because it foresaw a mechanism for dispute resolution between the state companies back in the Soviet times, whereby a claimant could apply to a chamber of commerce of the defendant to settle the disputes. These days we know that most of the companies are not state-owned. They belong to private capital, private equity. So the convention has a very limited application. However, there's still a chance. I mean, it's still in force for 5 countries, including Russia and I think Mongolia and Czech Republic and Hungary and some other countries too. So it certainly opens some doors to this whole mechanism of dispute resolution, although it hasn't been tried since the collapse of the Soviet Union. Back in 1977, Russian Chamber of Commerce, Soviet Chamber of Commerce, and the American Arbitration Association entered into an optional arbitration clause, which referred to Stockholm as an appointing authority. Again, it's still valid. No one terminated the clause, but the application of the clause is limited. Though the clause gave a whole legacy for Russian arbitrations, Soviet arbitration, and then Soviet, post-Soviet states arbitration in Stockholm, both under the UNCITRAL rules ad hoc, and these days Stockholm institutional arbitration is even more popular. Russia is a member to 71 bilateral investment treaties. 21 of them refer to Stockholm as a seat of arbitration, and the rest are UNCITRAL with the PCA as an appointing authority. And the good news is that Russia is a country, a model law country, adopted in 1993, and it's undergoing amendments. Hopefully will be in place next year. I think the second reading in the Parliament at the moment. And the amendments are aimed to bring the law in line with the latest UNCITRAL edition of the law, 2010. Okay. The law applies throughout the territory of Russia, which gives a good uniformity effect. So it's applied uniformly and in the same way by all the courts of all instances. What we have at the moment, well, if you go to a conference and there will be a Russian speaker, you'll hear only negative words about Russia. You'll hear that courts are very rigid and they're not in support of arbitration, and that enforcement is very hard. It's easy to set aside a award, etc. Though the reality is a little bit different, the situation is changing year after year, and we see that the regime, the approach of state courts and state authorities towards arbitration is improving. Where it comes from, basically from the 90s and the years of 2000, and as it was mentioned, an abundance of arbitration institutes, sometimes made for a specific company or even specific disputes, and led to unfair or even illegal arbitral awards in Russia, domestic arbitral awards, was really detrimental to whole arbitration in Russia. And the courts treated such institutes badly. There was a negative attitude towards those institutes, and I think that tradition continued until mid-2000s. But then with the new approach, new view of the arbitrage state court on arbitration, international arbitration, the situation started to change. And we see that today we enjoy broader arbitrability. For instance, the real estate disputes are arbitrable in Russia, which is the good news. It is plausible whether the shareholders' agreements are arbitrable, and my answer would be yes, and I think some judges would say the same. Of course, what is not arbitrable is the competition matters, criminal matters, administrative matters, but I think you will see the same situation elsewhere in Europe or even globally. A very limited application for those public cases. Then an interesting development happened back in 2011 when the state courts were agreed that they can give interim measures of protection in support of foreign arbitrations or domestic arbitrations, which is a big development, and it's been used by the business and legal community quite heavily these days, because sometimes you need a measure, you need to secure your claim, though arbitrators don't have any powers, enforceable powers to give awards on interim measures, orders on interim measures. So Russian courts are very helpful in this regard, and this is a very good news for us. Last year was a court's decision on the optional arbitration clauses, whereby parties may agree on a twofold dispute resolution clause. For instance, either they would go to state courts or to arbitration. And given the parties on that particular case, the courts decided that optional clauses are not valid because it stood to a detriment of a weaker party. And in order to protect a weaker party, you need to have a straightforward arbitration clause, whether it's an arbitration or a state court. And in that particular case, the court said that if there is dualism in any arbitration clause, then that will be referred to the state courts. The good news is there is no review on the merits. It's always been like that. It was questioned at some point in the 90s, but today it's absolutely clear that the courts cannot intervene and review arbitral awards on the merits, only on the procedural things, limited scope of challenges under the Russian procedural code, and including the challenges of lack of due process, lack of notification of the parties, non-arbitrability, etc., things which are commonly accepted globally. And the enforcement, which is significantly improved. It used to be 80% of the case. Well, during the Soviet times, by the way, the enforcement ratio was 100% because everything was enforced, because they were state companies and, well, they enforced their word voluntarily, so there was no need to go to the state courts. But in the 90s, somewhere about 80% of the cases taken to the state courts were denied enforcement in Russia based on the public policy or anything else. Today the ratio is much better. I think it's about maybe 40% of arbitral awards are not enforced, and the 60%, the rest of the 60% of the awards are enforced, which is much better than it used to be. Still there is a lot of room for improvement. We spoke about the arbitrability, and this is a general chart of what is arbitrable and what is not. Let's not stop here. But let's look at what's really happening with the Russian disputes, where they are. I mean, if we speak entirely of international arbitration, and the stats illustrate that most of the Russian disputes of substantial value are heard abroad, you see that 2008 through 2012, the stats illustrate that the blue column is the ICC in Paris, then Stockholm, the red column, and the LCIA. And you see this is the amount of the high value, high stake Russian disputes which are heard abroad. This is sad because basically Russian companies employ foreign specialists, legal specialists, foreign arbitrators, foreign arbitration institutes, etc. Though some of those disputes could be heard probably in Russia or in Belarus or Ukraine, one of the countries where one of the parties originates from. And I think that would be reasonable to bring some of them back, some of those which are not of a political nature or maybe do not have such a high stake of claim. But this is the reality. This is the reality. Russian disputes are mostly heard abroad, and I spoke to one of the barristers in London, and he said that he speculated that about 40% of litigation in the High Court of London has a Russian element in it. So you see that the foreign venues are very popular these days, not only arbitration but also litigation. And I think the tendency will continue, and that's if you look at the ICC stats, you'll see that the blue column is the Russian disputes, well, with a party from Russia. Then the red column is Russia is the place of arbitration, and you see it's almost none. So in 2011, only 1 out of 25 disputes with the Russian party was seated in Moscow, which is a humongous disproportion. And the third column is the number of Russian arbitrators. Again, it's nothing. I mean, 25 Russian disputes and only 3 Russian arbitrators. It's an illustration of how developed the community is and how Russian arbitrators market themselves abroad and whether they are recognized or not. And it seems that in those large venues, they are not simply recognized. In 2011, together with the ICC, we launched a survey on Russia as a place of arbitration, asking legal counsels and lawyers to rank the most preferable arbitration centers, what they think about it. And the Russian respondents ranked Paris as number 1, Stockholm as number 2, London and Moscow came only number 4, on the 4th place. Then foreign respondents went for Paris, Vienna, London, Stockholm, Geneva, Singapore and Moscow took only 7th place, with a comment to that a foreign company would only opt for Moscow if it's a deal breaker and no other. There would be no other chance to take an arbitration to Moscow, and this is very sad. It was almost 2 years since 2011 when the community started thinking of that, and only this year 70 law firms, legal professors, prominent lawyers came together to a chartered meeting and established the Russian Arbitration Association. It's founded by 50 companies first, but today the number is much bigger. It's a non-governmental entity, so we are not financed by the state or any big companies. It's solely based on the membership fees, on the income we generate ourselves from the conferences, publications, advertisements, etc., other seminars. And it's a non-profit organization, so all the money is distributed within the organization just for its own development. Here is the list of those who supported the idea, and you will find some familiar names to you. Maybe some of you work in those companies. This is a very prominent list of members of the legal community, and we are very proud that those ladies and gentlemen agreed to take part in this new development in Russia. The Arbitration Association is governed by the General Meeting, as you can imagine, which collects once a year, gathers once a year. On a daily basis, it's managed by the Board of Directors, and we have a reputable Board of Directors, including some of the known names coming from London, Paris, Kiev, Minsk, Russia, from big and small law firms. It's well represented. We have an in-house counsel from Alcatel-Lucent, which gives us some idea what is needed in the legal community. Then, in terms of dispute resolution, when we foresee that there will be a dispute resolution venue eventually established, we are discussing the rules. The arbitrators will be the sole arbitrators, and chairpersons will be appointed by the nominating committee, and then again we took lawyers of different generations and different backgrounds, both legal professors and arbitrators and younger professionals, those who know the legal community, both Russian and international. So they will be in charge of the nominating of arbitrators when it comes to nominating of a sole or presiding arbitrator. The objectives of the association is to, first of all, to provide for a new mechanism for dispute resolution of domestic cases. And then we will see, maybe it will go further than that for the international cases within the CIS countries. Maybe in the future will be also some pure international disputes, but we don't look further than just the domestic and the CIS disputes at this point, and I think it's feasible. Then we will have a very comprehensive arbitrators database, and we welcome all of you who is interested to go and see that. What criteria are applicable to arbitrators to have your name on the list. It's not theoretically, well, practically it's not the list. It's just a knowledge database on people. It's like Facebook for arbitrators, where you will give your profile, what you've done, whether you've sat as an arbitrator or as counsel, you teach, your rights, etc. Just all information, all personal and professional information about yourself. So the parties who take cases to our institute will have a look and look through your qualifications and see whether you suit particularly for their dispute. One of the objectives is the improvement of legislation, and we are planning to take part in the development of the Russian law on international and domestic arbitration, as well as the procedural laws and maybe the laws on the developments in the court system. We will have an education course for in-house lawyers, and on the other course for arbitrators, very much as it's done by the Chartered Institute of Arbitrators or by the Swedish Arbitration Association, just to develop the body of Russian-speaking arbitrators. And it will be good not only for for our institute, but I think for the entire world, because I think there is a certain lack of Russian-speaking, well-qualified arbitrators these days, and I know Stockholm is always in search for them, the ICC, etc. And we have a few names, but we need to have more. If you want to have a good business case, a good offering, good business offering for the legal and business community in terms of dispute resolution. And of course the knowledge database, it's pretty much like Kluber arbitration, will be articles and conventions and case law on Russian and CIS arbitration. When we speak about dispute resolution mechanism, the association will administer disputes, act as an appointing authority. We have a very extensive discussion with the Permanent Court of Arbitration to recognize as an appointing authority for ad hoc arbitrations seated in Russia. At the moment, there is no one who would administer those, who would act as an appointing authority for those. We will have an online arbitration for small claims. It's purely based on the documents, no hearings, nothing. Very simple claims, those which normally write off the balance sheets by the companies, say $10,000 US, $20,000 US. You wouldn't imagine to take that case to the state court or arbitration because it's not reasonable. You'll pay 3 times more to a lawyer than you will eventually get from the counterparty. So we will provide with this very simple mechanism based on the exchange of documents, maybe 1 or 2 briefs, 1-2 months, and then you get an award, simple award for debt collection or something like that. And of course the arbitrator's database. For the interest of time, I will skip the next slides, which discuss in detail what we are going to do in terms of the case administration and being an appointing authority. And go to the costs. This is very interesting, where we are in terms of the costs. If you look at the arbitration costs in general, which comprise administrative costs, which are paid to the institute, and the arbitrator's fees, then the situation for the claims, like 1 million, with the claims of interest, 1 million in interest, 5 million, 10 million, 100 million, you will see where the global institutions are. The blue column is Moscow, the red column is the ICC, then the green is Stockholm, and what we propose is the purple, deep purple. So you see that we are above Moscow, but still lower than Stockholm in some instances, but for the claims of 100 million US dollars, we're very much in line with Stockholm. You may say, well, what's your business case? I mean, it's a new institute, you don't have that much international, even domestic trust, and you offer the fees such as at the level of Stockholm. What we are trying to achieve is to pay more to arbitrators and to retain less for the institute. And the reason we would do that is because, say, International Chamber of Commerce, International Court, as part of the administrative fees go to the Chamber of Commerce, so it's shared with the Chamber of Commerce. We don't have any supervising authority above us, so all the administrative fees that we will charge remain with us. And it brings us to the same level as of the arbitrator's fees as in Stockholm, for instance, right? So we take less as an arbitration institute and we pay more to the arbitrators. And you see the breakdown for the amount in dispute. There'll be, I have a laser, right? This is the ICC, Stockholm, and Russian Arbitration Association. We are not offering a cheap venue. It will not be cheap because quality cannot be cheap. But what we are offering is a good remuneration for arbitrators, and this is our main objective, right? See, when it comes to the administrative fees, what the parties would pay to us as an administrating organ body, this is much lower than anyone. Look at Moscow, it's 2 times, almost even 3 times, and look at here, the Moscow is pretty much the Moscow Arbitration Court. It's as expensive as the ICC when it comes to the disputes with high value at stake. And it's a huge disproportion because they don't pay as well to arbitrators. Let's look at the breakdown. If you look at Moscow, for instance, the blue column represents what is paid to the institute. So what the MKAS, IKAK, charges and lives for itself, and only this portion is paid to the arbitrators. And this is for the disputes over $1 million. When it comes to the disputes over 5 million, it's even more. Like the blue column is growing, and what arbitrators receive, again, it's very, very small. If you look at the ICC, the proportion is all the way around. The institute charges a little amount of money, and the rest goes to the arbitrators. Even better situation with the Stockholm Chamber of Commerce. The very efficient secretariat, they charge very little and pay well to the arbitrators. And look at us, even more efficient, right? Very little administrative charges and very high arbitrators' fees. An interesting thing is, if you look at Moscow, basically an alternative for Russian companies, which they have, if not going abroad, for the high-value disputes. This is what the Institute gets in the disputes over $100 million US. And only this poor part is given to the arbitrators. Look at the ICC. 1/3 is charged by the Institute, and two-thirds, 2 parts, are given to the arbitrators. And again, that's what we offer. We'll have a very small portion because the administration of a dispute by the Institute is not very different whether the dispute is 50 million or 100 million. It's not about the value at stake, it's about the complexity of the dispute. So we will try to have a very little charge as an institution, and apportion larger costs to arbitrators. Let me see if I have anything else to say, and it seems that nothing, and I think my time is running. So thank you very much. I'll be happy to answer the questions, and I hope you'll raise some interest among you. Thank you very much.